Our next speaker will give the experience of Antigua and Barbuda in terms of access and benefit sharing. Ms. Nneka Nicholas, currently leads the legal work program for environmental work at the Department of Environment in Antigua and Barbuda, where she is a consultant. In her time with the Department of Environment, she has been instrumental in crafting and assisting in the passing of the Environmental Protection and Management Act, developing a model agreement for access to genetic resources for Antigua and Barbuda, and creating a multi-agency coordinated mechanism for the review of access and benefit sharing requests under the Nagoya Protocol. Ms. Nicholas, welcome to make your presentation.
Thank you so much for that introduction. Let me just share my screen. Okay, thank you so much for that introduction again. Just as an introduction, this is what the content of my presentation is going to be. I'm going to take you through the history of the access and benefit sharing regime in Antigua and Barbuda. I'm going to speak a little bit on the key provisions in the Environmental Protection and Management Act, some of the key provisions in our access and benefit sharing agreement, our experience on the ground, and the lessons learned in implementation of the Nagoya Protocol. So Antigua and Barbuda became signatory to the Nagoya Protocol on access to genetic resources in December of 2016. Prior to its ratification and before our environmental legislation was passed in 2015, we were still receiving requests for access to our genetic resources. And this was facilitated by a biomaterial transfer agreement. This arose out of a researcher from the United Kingdom coming to Antigua and Barbuda and going back to London with some samples of lichens in Antigua and Barbuda, from Antigua and Barbuda. When he presented these lichens to his research institution, he was asked whether or not he had an access and benefit sharing agreement, which allowed him to take these samples out of Antigua and Barbuda. When he told him that he did not have this agreement, he promptly contacted us again after the lichens had already left Antigua, and we did there was a biomaterial transfer agreement that was created out of scratch. This was before I had joined the Department of Environment as a legal consultant. The agreement was heavily criticized by ABS experts at the time. We had done a lot of work with the GIZ from Germany, and they did a lot of capacity building in the Caribbean region. And part of that capacity building was going through existing ABS agreements. And they would have provided some criticism that I had notes on it, but given the time, I won't really go into the criticism that they levied against the biomaterial transfer agreement. But after we became signatories to the Nagoya Protocol and after the passage of the Environmental Protection and Management Act, I would have revised the agreement to the agreement that we're utilizing today. But I will touch on one of the criticisms, which was that there was an exclusive jurisdiction for any issues to be determined under the contract. There was an exclusive jurisdiction in Antigua and Barbuda, and this was criticized because they said that this relied on the researcher actually coming back to Antigua and Barbuda for it to be heard in our high courts. And we discussed, it was highlighted to us that this is very unlikely that this would happen. And so that provision has since been taken out of our access and benefit sharing agreements to allow for it to be heard in a court of any competency in the world. So the Environmental Protection and Management Act was passed in 2019. Due to some corrections that had to be made in 2015, and due to some corrections that had to be made, it was repealed and replaced in 2019. And Part 9 of the EPMA contains the provisions on access to genetic resources and the fair and equitable sharing of benefits. So I just wanted to go through some of the key provisions in there, even though I think there are about 9 provisions under the access and benefit sharing regime. I will go through the key ones. So Section 76 asserts our sovereign rights over our genetic resources, and it makes direct reference to the provisions of the Convention on Biological Diversity. It is sort of descriptive on what is considered genetic or biological resources, and the language uses the word derivatives also, which is a matter of contention in CBD circles, because in our definition of derivatives, we include digital sequence information. And that is a cause of contention at the CBD level, because there are many countries who are, user countries who have large gene banks who have utilized digital sequence information from provider countries and are not willing to, pay benefits for the usage of this digital sequence information. Section 77 indicates that the provisions of this section are applicable to both in situ and ex situ accessions. So we do have some examples of our genetic resources in museums, in greenhouses across the world. And so we reiterate that the provisions of the legislation are applicable to both of those sorts of accessions. Section 78 speaks about traditional knowledge and related technologies, which is very important. And I won't go into the detail on traditional knowledge, because I believe the speakers before me did a very great job in going into why traditional knowledge is important and why it requires a protection and consideration under ABS regimes. I just wanted to highlight that in Section 78, we have indicated that the provisions do not apply to the exchange of knowledge between local communities based on their customary practices. So this is inclusive of customary practices of a lot of Rastafarians and naturalists in Antigua and Barbuda. And there's a lot of community exchange in Antigua and Barbuda. So the provisions do not apply to those exchanges of information between those communities. Section 80 speaks about the application procedure for access to genetic resources. So one of the best practices that we have utilized is not granting access and benefit sharing agreements, not signing access and benefit sharing agreements with individual persons. And rather we do with research institutions or companies. And this is because this is a lesson learned from other Caribbean countries where we've had persons who have been granted access to genetic resources, and they've basically just disappeared off of the face of the earth. So it is much easier for us to sign an agreement with a research institution or a company, so that in the case that any litigation has to come out of the agreement, it is easier because we have a company to identify. In the application, we ask for a specific description of the genetic resource that is being accessed, identification of any sites, identification of local communities that hold specific knowledge. And this is so that we are ensuring that they are going to be receiving benefits out of the access and benefit sharing agreement being granted. And we only issue a letter allowing access to genetic resources after an access and benefit sharing agreement is signed. So we sign our access and benefit sharing agreement prior to issuing the letter granting consent to access to genetic resources. Of course, when all of this information is communicated to the researcher, we indicate that there are other permits that they would need to take the genetic resource out of the country. And this is because these government agencies would have been in the practice of issuing permits like a phytosanitary certificate from the Plant Protection Unit and a similar one from the Veterinary and Livestock Division. They would have been doing this prior to the passage and implementation of the EPMA. So we have just incorporated this into the process, and they are made aware that they do have additional permits to get before they leave the country. We also in the application indicate that if there is a need for an environmental impact assessment because of the size of the accession, or if it is the material that they want to access is of a particularly rare or endangered species, we indicate that there might be a requirement for an environmental impact assessment. So far, we haven't had any instances where an EIA is needed, but it is something that is in the application so that the researchers are aware upfront that this might be a requirement that they would have to undertake. Sections 82 discusses the provisions of what a standard access and benefit sharing agreement would have. Within that, we've reserved there was a question in the chat regarding third parties, non-contractual third parties. On the advice of the ABS expert from the GIZ, and this is also it's considered a best practice among ABS practitioners, is that we hold the original signee of the contract responsible for executing the provisions of the original agreement. So whilst we do have some researchers indicating that there are some likely subsequent destinations, that's also a requirement in the application, we do require that they are the ones that are going to be enforcing the agreement if they are going to be sharing it with a third party, and failing to do so to enforce the provisions would have consequences on them and not the third party who would enforce against the original signee of the agreement. So I think I went through the procedure for the application. It's very simple, in my opinion, in my humble opinion. But the researcher makes an application to the Department of the Environment, as we are the competent national authority for access to genetic resources. And again, at this point, the researcher is informed about the entire procedure, including acquiring additional permits. The application is then shared with the review committee, which is comprised of government agencies. This includes the Plant Protection Unit, our Department of Marine Services, the Forestry Division, Fishery Division, the National Parks Authority, Legal Affairs, the Veterinary and Livestock Division, and the Ministry of Agriculture. And these technicians, these are sent to specific technicians who would have received training and been part of the capacity building. So they are aware of the issues that they need to look out for in terms of granting access to genetic resources. The decision on the application is then communicated to the researcher, and if approved, the draft agreement is then sent to the researcher. And at this stage, we encourage the researcher to seek the counsel of any attorneys that are attached to their institution prior to signing, because, and we noticed that a lot of researchers, this is not the language of the agreement, even though in my opinion, it is quite simple. Legal language is not within their frame of understanding, which is fair because some of the research terms are not in my frame of understanding either, but we do encourage them to seek the counsel of attorneys employed at their institution. We also require that when they are making the application, there is a letter of authorization from the head of department or somebody in a similar standing at their institution that indicates that this person is actually employed at or being utilized by the institution, and asking them to indicate that they're authorized to do so. The agreement is signed prior to the researcher being permitted to undertake any studies, and any other export permits, again, the researcher is required to get for themselves. So some of the key provisions of the access and benefit sharing agreement is the definition of biological materials. This definition is, as you see, it is quite extensive. Again, I've highlighted digital sequence data. Even though there is not widespread agreement across between user and provider countries on whether or not digital sequence information is considered genetic resources, under the Convention on Biological Diversity and its associated protocols, countries are free as their sovereign nations to determine what is and what isn't genetic resources. So we consider DSI genetic resources. Another key provision is the retention of ownership. We retain the rights over the samples of the biological resources listed in the annex. And it expresses that we retain ownership to the elements of DNA. Again, this very extensive definition of genetic resources. We have indicated, again, this is another lesson learned through our own experiences, through the experiences of other Caribbean islands, in the event that the user takes any step towards commercial use or commercial activities concerning the samples that they've received, that the government of Antigua and Barbuda is entitled to be the co-owner of any of the intellectual rights deriving from the research on the material or its derivatives and parts of the revenue arising from commercial use. So in the actual agreement, it does not speak about any commercial activities. The agreement is specifically for research purposes. And this is because we do indicate to the researcher at an early stage, at the application stage, that if they intend to do any commercial activities, then they would have to come back to Antigua and Barbuda to renegotiate the provisions of any commercial agreements. This is considered a best practice due to, instances of biopiracy and researchers profiting off of the use of genetic resources in their countries. And so we've included this provision in our ABS agreement. And again, this limit on activities provision speaks about the limit on the usage of the genetic resources. Again, this is to protect what we see as our intellectual property and our ownership and asserting the ownership over our genetic resources. So our experience on the ground, I've categorized it into three different types of experiences. We've had negative experiences with biopiracy. I spoke about the lichens, but we've also had issues of biopiracy in other Caribbean islands that we've learned from. One example I can give is in St. Lucia, where where a breeding pair of fer-de-lance or the pit viper were taken from St. Lucia, as well as some eggs. And, there was no ABS agreement in place. The person who issued the permit could not be found. But what has happened now with that breeding pair is that, they were able to, of course, breed the snakes and make antivenom, which sells for hundreds of dollars of US per gram of antivenom. And St. Lucia is receiving none of the benefits of this. Another negative experience we've had is with researchers not sharing data. So we've had to follow up with some researchers, and we've also had to try to communicate with the ABS focal point in the countries where the researchers would come from to indicate that the researchers are not sharing the data, which they agreed to provide in the access and benefit sharing agreement, so that we can get this information. We do have a sort of race to the bottom / jurisdiction shopping going on in the Caribbean. And this is because I think Antigua and Barbuda is probably one of 4 countries in the Caribbean region that has access and benefit sharing, legal access and benefit sharing provisions. And because of that, researchers have actually indicated, they've actually said to my face, well, your provisions are too strict, I will just go to such and such island. But of course, because we are close-knit in the Caribbean, we can, give the person the focal point for ABS a heads up and let them know that that is happening. And they do have their own, even if they don't have legislation in play, they do have like policy or an actual agreement in which they can enforce. Larger user countries not being in agreement with the definition of biological resources, I would have indicated that the DSI is a very contentious issue at the convention, in the convention circles. And this is because what provider countries are seeing as these user countries not being in agreement with sharing the benefits that they would receive from the data, from their data banks that has our digital sequence information, because people are paying for accessions to these to this data and this information, and we are not getting the benefit. Neutral, we do have adherence to the provisions of the agreement, and a lot of the researchers that do come to Antigua and Barbuda now are well aware that we are signatories to the Nagoya Protocol, and they do their research beforehand. And of course, we have our EPMA online for people to access, so they are aware that this is a requirement before they can access any of our genetic resources. Some of the positive experiences that we had is that we have data on Antigua and Barbuda's biological resources that assists with DOE's projects and conservation efforts. So earlier, one of the slides that you saw earlier was a goat on Redonda. Redonda is one of our islands, one of our little islands that we have been able to rehabilitate through the efforts of the Environmental Awareness Group in Antigua and Barbuda. It is a lesson, this is an example of conservation and utilizing the ABS for the purposes of conservation. So prior to the Redonda Ecosystem Reserve being rehabilitated, we would have had researchers from Harvard University going over to do a study of the lizards, which can only be found in Redonda. Did a study on the lizards and their diets, what they've been eating since the island was basically raised of any vegetation because of the goats that were living on there. The goats were removed, all the rats were removed, and the island is still in a state of, well, not in a state of recovery. And when the researchers came back a year later, after all of those invasive species had been removed, they were able to document significant changes to the morphology of the lizards, including longer toes because there's more trees to jump from, the better, more expansive diets because the vegetation and whatever insects would have come back. We've also had positive experiences to share with Caribbean counterparts to encourage them to ratify the Nagoya Protocol. This is a constant activity that we're doing, encouraging Caribbean countries to become signatories. But even if they are not signatories, we do encourage them to have some sort of policy in place or some sort of agreement in place. And for the last slide, the lessons learned. Again, ABS contributes to the conservation and sustainable use of natural resources, as well as knowledge about our biological resources. All of the research and information that we receive from researchers, we deposited onto our environmental registry for people to have access to, free access to, so that they don't have to go through the various databases where you are required to have paid access. Again, it's contributing to the conservation of our biological resources. We've had studies done on Redonda, we've had studies done on our frigate birds in Barbuda, we've had studies done on our sea turtles, and this is contributing to us coming up with policies and other measures for conservation. Non-monetary benefits is mainly what we've been getting. We have yet to get a nice agreement that has some monetary benefits to Antigua and Barbuda. But what we found is the non-monetary benefits, because there is a requirement in the agreement that researchers must utilize local counterparts. So that could be government agencies, non-governmental organizations, students from our local state college. We are getting a lot of capacity building within the country, and it's getting a lot of people interested in conservation, and that's something that we constantly need in Antigua and Barbuda. Another lesson that we've learned is that direct monetary benefits from sample collection is not likely to be significant. These are researchers, they have money to come to Antigua to study, and that is the end of their money. Again, we haven't had any commercial usage that has come out of our accession to our genetic resources. And so we have not received any significant or any direct monetary benefits from our access and benefit sharing. And what we have also found, a lesson that we've learned, is that clear procedures are enabling practice for implementation. And so because we have clear, simple, and transparent ABS procedures that are easily accessible on our website, or by simply reaching out to myself or another member of our technical staff, there is legal certainty, and we do have, more often than not, any conversations that we have with researchers ends up in a successful signing of an ABS agreement. And thank you for being an attentive audience, and that is the end of my presentation.